the regulation itself clearly states, my lords, in the regulation that already passed, my lords, regulation.
Let's see the regulation directly. Which page?
Page 15, and now this separately had given the full regulation, my lords. The page 59, the third page, lots of the regulation, lots of see. It is 3.3 point Roman 2.
Yes.
The clearance of net slate set shall not be required for candidates in such discipline for which net slate or set has not been conducted. In every course with specific qualification, there a specific note is given to the same effect.
Yes.
The second question, my lord, what should happen when there are no eligible candidates? This, my lords, I tried to look into whether similar situation has occurred somewhere else, my lord. I could lay hand on a judgment by Punjab and Haryana High Court, wherein, my lords, in the state of Haryana, there are several bunch of matters where single judges have passed judgment, my lords, wherein they have said that they, from 2020, my lords, state of Haryana has taken up a policy to streamline their rules to make it in consonance with UGC guidelines, my lords. Wherein the same situation has arisen, and learned single judges in 2-3 batches of matter have clearly heard that for those there is a practice of extension of lecturers. They were continued, giving every year some extension.
They're not doing that here, they're doing it recruiting.
They're doing it in a different way, but my only concern is that there, the view was, my lords, the view taken was by the learned single judges in series of matters that in so far as for so many seats for which they don't get the eligible candidate, for then these eligible candidates were continued. And in this repetition, what happened, my lords, some of those, when the
They're wanting it for 1 year, he's applying.
yes, my lord, that's what my only submission is. Why I wanted to bring it to your lordship notice is, in the writ petition, such petitioners who were continued like that, when they were terminated by the state, when they had good enough number of candidates, they had approached the division bench, my lords, and the court has held that they have no such right. But the state can discontinue when they have it. So far, they were continued as a temporary arrangement. Hence, my lord, my only suggestion is that this I may not, as a counsel for UGC, I may not be able to take this stand, but with great respect, lord, but I leave it to the lord.
We'll pass like the order that you want. Let them, on the basis of what they say, after some arguments.
Please.
The learned counsel appearing to the appellant submits the leave and the directions issued by the learned single judge to be complied with. He, however, points out that there are various be complied with, and the guest faculty would be appointed, and only those persons who qualify the eligibility conditions is stipulated in UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges, and measures for maintenance of standards in higher education 2013. Put this in quotes. Shall be appointed as guest faculty. Full stop. He also submits that there are various subjects where for which the relevant qualifying exams various disciplines for which relevant qualifying exams of bracket net oblique SLET oblique set bracket close have not been conducted. He also points out that there is that number of in certain disciplines the number of candidates available would be less than the requirement. The qualified candidates available would be less than the requirement. He has handed over a memo regarding the guest faculty details. Has handed over a cabinet statement setting out the details of the guest faculties. Or the number of the requirement for guest faculty for the academic year 2025-26. The same is enclosed with this order as the same is annexed to this order, appended to this order as and marked as Appendix 1. Full stop. Next. This said tabular statement does indicate that in certain disciplines, such as
Serial number 7,
computer sciences, the number of the requirement far exceeds the number of applicants with the requisite qualifications. Full stop. As an interim measure for the batch for the academic year 2025-26. The next class. As an interim measure for the academic year 25-26. The appellant be permitted to hire guest faculty in those disciplines. And that was also permitted to hire guest faculty. Or hire engaged applicants who do not fulfill the qualifications of NET, oblique SLET, oblique PhD. In certain disciplines where the number of qualified candidates falls short of the guest faculty required. Full stop.
and also
Insofar as the petition, the appellant's contention that there are disciplines where the qualifying exams NET oblique SLET has not conducted. The Unit Council appearing for UGC has referred to Regulation 3.3 bracket 2
Roman
2, which expressly provides that clearing of the said examination would not be required for candidates in such disciplines for which said examinations have not been conducted. This would address the petitioner's appellant's apprehension in this regard. Next. In order to obviate any ambiguity as to the qualifications of the as to the minimum qualifications, we consider it apposite to set out paragraph 3.3 of the aforesaid regulations, which read as under. We'll just take paragraph 3.3. So put this when we put the regulations.
In that, my lords, only one thing is, lords have recorded my submission that we are stating that we will follow the UGC guidelines from this year. My submission, my lords, was that we are seeking for 1 year extension that we will follow from next year. My lords can reject it because that way it will be better.
The Learned Council of the Appellant submitted for the academic year, but after some that it said that the appellant would follow the follow the decision of the learned single judge in the academic year 26-27. However, the summit set for the academic year 25-26. The appellant may be permitted to engage guest faculty, engage persons who do not qualify the NET, SET and SLET examination. SET, NLSET, SET or PhD. In view of, for two reasons. First, that the requirement far exceeds, in certain disciplines far exceeds the number of applicants. And second, that in certain disciplines, the qualifying examinations have not been conducted.
We make one submission.
Submission laws in the regulation that the Lordships are directed to extract. There is a small amendment that 3.10 is subsequent amendment. That means that I'm just following.
What is the
That 3. The extract, Lordships are directed to extract. That 3.10.
we are only extracting 3.3.
Then no. Yes.
Paragraph 1 and 2.
No, then no.
That is the relevant.
Yes.
May we make a request where before the learned single judge. But we are not parties before the learned single judge who has filed the present writ petition which is impugned by the order. But we have also filed a writ petition challenging the seeking review of that learned single judge order which is pending adjudication.
Once we are keeping this pending, there is only one.
Yes. No. Now by virtue of your lordship's order.
Only an interim order.
Yes. Because in the other batch of writ
Our
petitions.
counseling is happening now.
Yes. No. What happened is similar. From past.
Because it's happening now. So there has to be some directions to.
No. We have been continued by virtue of the interim orders passed in the earlier batch of writ petitions. We are working since from past 15 to 20 years as a stopgap arrangement by relaxation by the UGC regulations by the state government. We have now been also been continued by the learned single judge where 25-26 notifications are very issued. That has been stayed. Therefore, by virtue of your lordship's order, the batch of writ petitions where we have obtained the interim order, we are nowhere.
Right there.
Here in the
Right there. You'll be right, but we have examined this position and we agree with what
Therefore,
happened.
the petitioners who are already working on from since past many years, who are under the by virtue of the shelter of the interim orders in a batch of other writ petitions, may also be protected our request.
Can't be protected. This is never end.
Otherwise, we have been condemned without hearing. Even before the learned single judge where we sought for review, interim orders are operating in a batch of writ petitions. The state government will produce your lordship's order and the interim orders will be modified.
Not awaiting what happens with the writ appeal. And based on either the final this interim order will be placed. And we had stated that till an order is passed in the writ appeal. So continue because the classes have to go on. So now the Lords will be placing this order.
They are not
That's
not the counseling everywhere. I shall for 2 minutes. These guest faculties are not continued from past several years.
There is an order passed by the learned single judge. We have examined it. We don't find any error in it. What do you
Look, we are saying where your lordships are examining the writ petition with the learned single judge orders, where we are not the parties. It is some of the other candidates who have filed. Therefore, we sought for review of that order.
are to be decided. It's not that
that is on the ground before we sought for review, because UGC regulation itself will not apply because the persons who have been working, the UGC regulations the state has not adapted and the payment is not by the UGC. That is the view is taken by the Supreme Court.
I'm not arguing that. I'm not arguing that. Their case is that yes, faculty is not.
No, they have been appointed by virtue of a special rules. Look, the state government has appointed us by virtue of a special rules continued from 96, 2010 and 2020. Look, that is not, they have not argued. Because they have not argued, we will be, our rights will be at at Bleak Millard. We have also obtained the interim order now, the reluctant single judge Millard by virtue of the modification to be effective without hearing.
It must obviously follow from this order. This order is obviously would follow if the learned single judge had reviewed this order.
In fact, what happened was,
If your lordships are concurring that order, it will not arise.
there was one petition which was filed, my lords, where the prayer was to seek for review, my lords, of the order of this order that the learned single judge had passed. So that petition was placed before the very same learned single judge. All the other petitions which were filed, in fact, got connected to that, and it's before the very same learned single judge. He is awaiting, my lords, the orders by the division court.
There are two issues.
We will place it before the court. my lords.
There will be an issue because if he is saying that there is another argument,
Please.
the UGC rules are not applicable. Somebody will have to examine it. Yes, at some stage.
Till then,
There has to be some prima facie case. In our case, we are not prima facie accepting that view, but assuming that you want to have your say, we'll have to find out.
No, my lords asked me a pointed question. If I'm appointing a regular lecturer, will this regulations apply? And I answered, no, it applies. So the fact that they
Your
are
only argument was
is
that
that guest
that is
is
different for you. That guest is not contract employment, and it's
that was my argument. I stand by that argument, my lords. And in fact, my lords, in so far as the regular appointments to the first grade colleges are concerned, I am following the UGC regulations. So there is my learned friend saying that
they have been appointed in some
special rules, yes. There are special rules. 96 rules is there, 2010 rules is there, 2020 rules are there. If I provide an opportunity, I shall argue that.
This is list for hearing. Have you filed your
There are implementing applications which are still pending in order.
Where is your implementation?
IA number.
They are all before the.
Single judge.
So you tell us here, we'll implement if you want to hear us, then we'll, because we are not prima facie following this argument that UGC has one regulation, the regular regular faculty will be done by that regulation, but some special carve out will have to be made for you, and that should be continued in perpetuity. That's not something that we are
May
ready
I organically request another prayer? If your lordship may keep it open the review petition, we will also argue there in the next week itself.
We need to close this, there is some certainty to everybody.
Yes.
And this is not a way to go about certainty. That's the reason why we're not disposing of the petition and something else.
Now we are on
We can-
the street, my lords.
Start the street 15-20 years, you have the option to get those qualifications. The qualifications are there in regulations. You can't perpetuate by, and this argument we heard by one of the councils who appeared espousing it, by saying that there is persons of 55 years and 54 years. We can understand that there is an issue here as far as legal views is concerned. There may be prejudice. Doesn't mean that the qualifications has to be relaxed. We are not able to follow it.
May I make one submission? There is one more issue which is not decided in this present implement order was the MPhil, those who have passed MPhil qualified candidates are exempted from this Millard, NET and SLET.
Those who are,
Passed MPhil as on 2009 prior to 2007.
we are saying this,
That is
as
not
far
decided.
as the UGC qualifications are concerned,
Yes.
that will apply.
No,
Even
even
they are exempted and
They
state.
are exempted, they are exempted.
That issue is pending before the single judge.
We are- we put that.
even
That clarification is pending before the other issue. That is not issue. That is not decided here.
That's not decided.
Yes.
even for technical, yes.
That we have to. I have clarified not within
This point is the form. This point is the form that there are certain other. There are certain other.
those who are qualified MPhil Millard.
Who are claiming exemption from UGC. Who claim that there are specific exemptions granted by the UGC from the, in respect to the aforesaid qualifications. Needless to state that there are some, the UGC has exempted certain category of persons from the applicability of those posted regulations. The said exemption, if any, would, this interim order will not affect.
Yes.
This exemption.
Ladies,
Here we want to be.
My lords, if I may be permitted, my lords, it is not so easy for these petitioners to register for PhD, my lords, or to appear in these examination. The passing rates are very less, my lords. It's not that they have not tried at all, my lords. They have been trying.
There are candidates who have crossed this exam. If they are available, then obviously the students will have the benefit of those. There is an expert body that has framed these regulations.
The state
The
will have
fact
to take
that-
some policy decision for the number of years they have served here, my lords.
Policy decision is a student should get the best education.
It's not that we are not teaching, my lords.
So if some threshold has been fixed by the EEC, that has to be crossed.
Last year also they did not conduct any counseling. They have been continued. Therefore, the state requested, please continue for another year.
Our hands are bound by the law. Unless we come, that is why we want that these regulations do not apply. We can't. No, it's not available for us to alter the statutory regulations on the one, even if we are persuaded to. So all we can do is give some sympathies, but we can't give an order. So
That is why we wanted to request before the court to give an opportunity of hearing. In order to
Till it is a message as far as this academic year is concerned, this interim order we hear you on that.
So that
if you are
they will be out of service. They will be out of service. The persons who have been teached for, now all of a sudden the persons who have been taught for 20 years, now they have been set, you are not qualified.
This service is not a regular service. You've been appointed year to year.
That is like Manish Gupta's case, your lordships are aware, the Supreme Court in a guest faculty's case only have heard, unless the regular recruitment is there, you cannot be registered. You have been continued.
Also, one set of guest lecturers cannot be replaced
By another set of guest faculty is also there. If this order is being given effect to by the state government,
Faculty have to appoint.
that is why we requested kindly continue us which have been continued earlier and hear us and another for 2 months or 3 months, so that the pleadings will be completed. We will argue, address our arguments. Previous also here they have taught, now continued, persons who did not. That is the problem.
The latest regular, we appointed 1,400 people.
Total number is 10,000 and 7,000 is regularly appointed in the lectures. 3,000 may be fluctuating because of various new courses or such kind of or absence of students at some particular place. But that cannot be 2,000, 3,000.
Increase in strength.
Clearly on your point if you want,
Yes,
but not, but that's post interim order because we don't find any primary.
we are also requesting the court. The lordships now have exempted the subjects in which the qualifications are not there. Not there. We have also standing on a similar footing where we have been extended from last 15 years.
Where there is no eligible candidate, obviously they will still have to run the. You are not assured eligible candidates being there who are not being appointed because you are employed. That's the issue. But you tell us, we hear you also.
It is not the case where there is a scarcity. They have been.
You can't hear arguments in this manner.
Yes.
You have a point.
Yes.
You make on this. You make the point, we'll hear you. That's what you will say.
All pleading applications intervening could be allowed so that if they have
That's
the
right.
right.
Let me allow it. Please.
Let them not disturb our.
No, that's not correct. There are a large number of,
Even before the learned single judge.
large, just give us the implement application that you file. And we'll allow it. We can't have 20 applications. You'll have to demarcate on who are the existing ones, who are not going to be here. We can't have 20 councils on an implement.
So I think the main implementing applications were filed by UGC qualified candidates who are on the other side. Maybe now that their interest is protected, I think they're
I remember reading your lordships.
So UGC candidates were there, we are accepting that panel basis. So you can watch these proceedings. If anything adverse order comes to be passed, then you can.
Please,
all the applications will be listed, but also some other.
All of the applications will be listed on. Give a list on dash for further proceedings. All applications for implement and intervention be also listed in the next day. Once list for further proceedings will start. The endeavor would also be made to hear the parties seeking implement or intervention, public intervention in the present.
We are also requesting one more request, that the contentions which have your lordships now dealt with, that contention which has sought to be reviewed may be kept open, so that we will also address if it is that reviewed.
An interim order, that's why we placed it in interim order. The current also wants to, because the currency situation, the interim order is, the division gets the interim order is placed before the learned single judge. He will say, I have nothing to consider, it has been modified. We understand, that's why we are saying you want to argue anything, we give you full opportunity to argue. You can't say that we are not, you are not arguing here, but we must now protect you. On grounds that we don't agree. That's what I'm saying. If you persuade us, we'll pass a final order. We are yet to pass a final order in this. Next week, we'll fix it so that our rights will be crystallized. Give you a date. This has been put urgently for the mentioning by the learned council. But the counseling is happening today. That's why you give it 2 weeks time. You make your written note with whatever authorities you want to rely on.
8th of October.
Parties are at liberty to file their short note submissions, propositions along with the list of authorities along with the list of relevant authorities. Not parties, the council.
Grateful.